achieve by the end of this presentation. Wherever you hear the word intellectual, it involves creations of the mind. It includes literary and artistic works and symbols, names, and images used in commerce. So that's what we mean by intellectual property. And it is divided mainly into two branches: industrial property and copyright and related rights. Those are the two main branches of intellectual property, but there are also other emerging categories which we'll discuss in this presentation. Industrial property, that's the first branch of intellectual property that I would like to talk about. It includes patents. I'm sure some of you might have heard about patents. You might have not known what patents are all about, but you might have heard about patents. So we'll discuss patents today. So it includes industrial property, includes patents for inventions. It includes trademarks, industrial designs, and geographical indications. I've said that the IP is mainly divided into two branches. The other one is copyright and related rights. And by copyright, we mean those rights that cover literary works, such as novels, poems, and plays, films, music, artistic works, such as drawings, paintings, photographs, sculptures, and architectural designs. But there are also rights which are related to copyright. Sometimes they are called neighboring rights to copyright. And those include rights of performing artists in their performances, producers of phonograms in their recordings, and broadcasters in their radio and television programs. Now, I've said that IP is divided mainly into two. So you'll see that these ones, is this pink? It looks like, eh? Yeah, the ones in pink, that's industrial property. And then we have copyright. We have copyright in green. And the other emerging categories of intellectual property, such as trade secrets. You have plant varieties, traditional knowledge, and layout designs of integrated circuits. And for the sake of this gathering today, I will mainly talk about patents, trademarks, industrial designs, copyright, trade secrets, and layout designs of integrated circuits. I hope I will manage. We are always taught to live within our means. So I will try to live within the time, to do this within the time that I have. Okay, so I have only 45 minutes. I hope I will make it. Good. The discussion will be interactive. I'll be asking you questions. Feel free to respond. I don't want to be talking, and I don't usually do that. To talk, and then I exhaust myself when people are just looking at me and they exhaust their eyes. Okay. What is a patent? Anything you might have heard about patents. Quickly, we don't have time. It's only 45 minutes that I have. Who has ever heard about a patent? Yes, yes. Who else? Yes, yes, please. Could you explain what is a patent? As quickly as you can and briefly.
So a patent is a form of intellectual protection which gives the right to somebody who have invented something, say a machine. So a patent then gives that inventor the exclusive right to commercially exploit that invention for a period of time.
If it were any church, I would ask for a special collection for you. Thank you very much, my brother. That's exactly what a patent is. Very good. Thank you very much. So a patent can be defined as a legal document that describes an invention and grants a property right to the inventor or inventors or the owner. That's what a patent is. It can also be defined as an exclusive right granted for an invention, which is a product, meaning that the invention can be a product or a process that provides a new way of doing something or offers a new technical solution to a problem. When we say an invention, we mean something that is used to solve a certain technical problem. You just don't invent for the sake of inventing. You should be solving a certain problem with your invention. So an invention is generally a new, inventive, and industrially applicable or useful technical solution to a given technical problem. That's what a patent is. Now we are using the word exclusive. A patent gives the owner an exclusive right for an invention. What do you think is meant by exclusive right? Quickly. What do you think is meant by exclusive right? Yes, please. If you can speak up. Wow, that's beautiful. Beautiful answer. Thank you very much. Thank you very much. That's what it means. What it means is when you have created an invention, then you protect it and you are given a patent. You have the patent right to exclude others from exploiting your invention. By exploiting, I mean manufacturing it, selling it, using it. You exclude others from doing that. They can only do that with your permission. They can only do that with your permission or consent. That's what it means by the rights being exclusive. Okay. What can be patented? It can be a product, a composition, or for example, a chemical composition. It can be an apparatus, a process, or just an improvement of any of these, either a product, a composition, apparatus, or process, any improvement of such. You know, patent rights can be granted for non-complicated things. When I was growing up, before I grew gray hair on my head, we used to call these money clips when money was all around us, cash was all around us. But now we use it by its correct name. It's a paper clip. You see, such a simple thing was patented in German long time ago. Post-it, as simple as it is. Post-it, does it solve any problem? It does, eh? Yeah, so that was invented. So a patent can be granted for not complicated features. But then what requirements should be met if an invention is to be protected using a patent? So I'll give you 3 requirements, basic requirements that must be made for a patent to be granted. So patents are granted for new inventions. It must be novel. The invention must be novel. It must be new, first in the world. Then you can ask the question, how do you know that it is first in the world? Yeah, okay. It must be first in the world. It must have not existed, or someone must not have used it before. You are the first one to bring up that invention. Okay? So, that means that prior disclosure of an invention means that you cannot have a patent for that invention. I think the earlier speakers talked about prior disclosure. You just don't go about going to town with your idea. Everyone in town knows about it before you even protect. That's where the danger is. Prior disclosure of an invention must be avoided. Never disclose your IP unintentionally. Or you could have a good reason, but if you do it without protecting first, then you can run into problems. So you need to have a non-disclosure agreement in place as a matter of course. If you want to engage other people, maybe to help, to work together in working on the invention, you need to have that non-disclosure agreement, okay, so that you are protected. Otherwise, if you do that, anyone can go and can take away your idea or your invention, and they can push you out of business. ARIPO, the African Regional Intellectual Property Organization, I said it's an intergovernmental organization. We have 19 member states which mandate us to grant patents on behalf of those member states. So there is what we call ARIPO Harare Protocol on patents and industrial designs, which mandates the organization to grant patents and register industrial designs on behalf of the member states. In that protocol, a disclosure of the invention at an official or officially recognized exhibition, when you do that disclosure at such an exhibition, the owner is allowed to file a patent application within 6 months. So you have made a disclosure before you file an application for a patent. By official exhibition or officially recognized exhibition, these are the ones that are recognized by government. As I will say later on, it is the government that that grants the patent. So once you disclose it at such an official exhibition or function recognized by government, you are given 6 months to file for a patent. If you do not do that, if the 6 months elapse, then you are not protected. You cannot file for a patent. Okay, the second requirement for patentability of an invention, it should be industrially applicable, or we call it industrial applicability, okay? Meaning that it can be mass produced and used in some form of industry. That's the second requirement. The third one, it must be inventive. What do we mean by that? It must show ingenuity or inventiveness such that a person of average skill and knowledge in the field of the technology cannot easily understand it, or it is not obvious to such a person who has average skill and knowledge in the technological field of the invention. So these are the 3 basic requirements that need to be met if you want your invention to be protected using a patent. Okay. But these patents, how do they promote innovation and business? Can I have two ways how does a patent, or how do patents promote business and innovation? Who would like to try that one quickly? Yes, yes, please. If you can speak up since you don't have a mic. Great. Thank you very, very much for such a correct answer. Indeed, that is correct. When you are protected, I'll say later on, but you are protected for a patent, you are protected for 20 years. Okay? Once you are given a patent, it is valid for 20 years. You are protected for 20 years. So during those 20 years, you have the exclusive right, you have the monopoly of exploiting that invention. In other words, you can manufacture and sell and use it. You can license others to manufacture or use it. You can do a lot of things to recoup the investment that you put into research and development. So that is a motivation. It promotes innovation as well. Because who would go on innovating and is not protected? Whatever inventions they come up with, they are stolen by others and they don't recoup the investment they put into research and development. Who would be motivated to do that? No incentive would be there. Okay? So that protection gives the motivation. Okay. Good. Now, how does the patent right holder recoup their research and investment expenditures? So I've given 3 ways. One, you yourself as the owner of the invention, you can manufacture, you can use, you can sell the product or the processes incorporating the technology covered by the patent. You have that exclusive right, okay? Secondly, you can license others. Since you have the exclusive right, those who would like to manufacture or sell or use your inventions can only use that with your consent, with your permission. And one way to allow them is to license them. You license them, and of course, in return for remuneration. Okay, in return for remuneration. That's how you can recoup your investment in research and development. You can also assign your rights. By assignment, I mean you can sell your right. Okay? If you sell it, then you have sold it. It's not yours. Okay? So you can sell your rights to someone else who then becomes the new owner of the patent. It's the same as I buy his car. All the documentation concerning that car should be given to me because I'm now the new owner of the car. You see, that's also what happens. So those are some of the ways that a patent right holder can recoup the investment that they put into research and development. Protection, patent protection provides the right holders with the means to defend their rights. There can be infringement on your rights. By infringement, I mean that someone is using your rights without your permission. Okay? Someone is using your rights without your permission. So that's infringement. So you can, if you have a patent, you can use that to defend your rights in the court of law. Or you can even initiate legal proceedings because you have a document that shows that you are the right holder for that patent. Okay? And again, in return for patent protection, all patent owners are obliged to publicly disclose information on their inventions in order to enrich the total body of technical knowledge in the world. The issue is we do not want you to die and then you leave an invention which cannot be exploited. When you are protected for 20 years, for example, and then at the end of the 20 years, protection lapses. And then the invention goes into what we call the public domain, food for all. So anyone can exploit it. So it means because you disclosed, someone can just come to your patent and read it, and they understand how your patent, your invention works, and they can manufacture it or sell it or whatever. But by disclosing, you enrich the the total body of knowledge, technical knowledge in the world. Who grants patents and for how long? That's now where we talk about where do you go if you want to apply for a patent. Patents are granted by national IP offices, national intellectual property offices, or by regional offices that carry out examination work for a group of countries, like ARIPO, African Regional Intellectual Property Organization. We have 19 member states. We are a regional office that carries out examination for a group of 19 member countries. Okay? And we also have a national IP office in Zimbabwe. What is it called? What is it called? Can you speak up? That's correct. Can you speak up? Thank you. What does ZIPO stand for? At least he has given us the answer. I want someone else now to give us. What does it stand for? Yes. Zimbabwe Intellectual Property Organization, that's what he thinks. Who? Yes? Zimbabwe Intellectual Property Office. The O is office. Yes, thank you very much. Zimbabwe Intellectual Property Office. That's the national intellectual property here in Zimbabwe. Zimbabwe Intellectual Property. If you do not know, this is an office that you need to know about. Okay, so examples of regional offices I've said are RIPO. We have 19 member states here in Africa. And there's also another IP office, regional IP office called OAPI. That's in French, but it's called the African Intellectual Property Organization. It's headquartered in Yaoundé. Yaoundé is in South Africa, isn't it? Where is it? Cameroon, very good. That's where the headquarters is, and it has 17 member states on the African continent. Another example of a regional organization is European Patent Office. There are some others. Okay, so duration of protection, as I've said earlier on, is generally 20 years. It depends from jurisdiction to jurisdiction. But for us in the ARIPO member states, if you use the Harare Protocol I talked about earlier on, the patent is granted for a period of 20 years, just to give you room to exploit, to make money using your patent. Okay, this other bit, I already talked about it, the public domain. Good. Territoriality principle. IP rights, including patents, are territorial in nature. What do you understand by territorial rights? Territorial rights. Quickly, please. Yes. Great. Thank you very much. That's exactly what it means. Okay? You remember earlier on I said that patents or IP rights are granted by National IP Office. A National IP Office is a government office, okay? Regional offices, they are also somehow government offices because they are mandated by a number of governments, okay, to do that, okay? So protection is territorial. What we mean is that if you are not protected in Zimbabwe, you are not protected. It means that if your invention is, you get a patent for your invention and you choose Zimbabwe as your country of protection, then, and you don't protect in Zambia, then people in Zambia can exploit your invention because you have no protection there. Why is this so? Why are IP rights territorial? It is because the IP rights can only be enforced in the territory governed by that state or country that grants the right. If the right is granted for Zimbabwe, it can only be enforced here using the rules or the laws of this land. Okay? We don't have common laws worldwide. We have laws that apply to Zimbabwe, to Zambia, Malawi, and these other countries. So that's why protection is territorial. So when it comes to enforcement, in case of infringement, it is the national law that is used for enforcement. Okay, now, there are also some patents which are called petty patents or utility innovations. We call them utility models also. Okay? So when we talk of utility model, basically we talk of an exclusive right granted for a minor invention which does not require to satisfy the test of inventiveness as required for a patent. You remember the three requirements for patentability? It must be novel or new, the first one. The second one, industrial applicability. The third one, inventiveness. Okay? So for utility models, you only apply the first two. It must be new and useful. Okay? Industrial applicability. But the inventiveness, because these are minor inventions, the inventive step is not considered. So a utility model is registered if it is just new and industrially applicable. So I said patents are granted for 20 years. For utility models, they are minor inventions. They are granted for a period of 10 years. After 10 years, it goes into the public domain. People can exploit it commercially without infringing on your right because your right has expired after 10 years. But why should a patent application be filed? The key reasons. When you have a patent granted for your invention, you have a strong market position and competitive advantage. You remember the issue of exclusive rights? You can boast, walk high on the market because you are protected. Okay? You have a competitive advantage over others because there could be others who free riders and imitators on the market. And when you apply for a patent and it is granted, then you have a competitive advantage because your free riders and imitators will have to get permission from you to exploit your invention. And the market entry barrier for competitors in respect of the same invention. If you are protected, no other person can bring a similar thing on the market because you are protected. As I said earlier on, you're also recovering your research costs. You can also, why should you patent apply for a patent? You can license or transfer or sell the patent right. That's making money. You have access to technology through cross-licensing. What that means is cross-licensing. Anyway, what does that mean? What do you think? You have been very good and putting up hands very quickly. Please, cross-licensing. Okay. Cross-licensing, it just means if I have a patent for an invention and someone has a patent for a different invention, can cross each other. I get a license to exploit their invention, and they get my license to exploit my invention. That's cross. Okay? You can access new markets because you are protected in those markets. If you are protected, if you apply for protection in such markets. Diminished risks of infringement. And image. Finding business partners and raising company's profile and market value. When you have a business that has patents, the commercial value of your company is better than businesses which do not have. But now, it's not just a matter of applying for a patent. There are factors you need to consider. Because when you apply for patents, you also pay fees. Otherwise, our organization would collapse. We rely on the fees that we get from applicants. Okay? There are factors that you need to consider before filing a patent application. One, you have come up with an invention. Is there a market for the invention? Because you can apply for a patent, pay the fees, but you don't commercialize it, you don't even have a market for it. Is there any benefit for doing that? No. So you have to consider, is there a market for the invention? Are there potential licensees or investors who will be willing to help to take the invention to the market? You identify the market, but possibly you may not be able to take the invention to the market yourself. Are there potential licensees, people or companies you can license, or you can give permission to take your invention to the market? Or are there any investors who may want to bring in resources to take your invention to the market? How valuable will the invention be to your business and to your competitors? So it has to be something that is valuable. Otherwise, you may not want to apply for a patent if it is not valuable. It's of no value. It will not bring any value to you. Another question you ask yourself: do the expected profits from an exclusive position in the market justify the cost of patenting? You project, if I apply for a patent, the cost I incur for patenting, do they really justify the profits I will get on the market. So those are some of the factors that have to be considered before you apply for a patent. Okay, let me quickly talk about trademarks. I'll just use this slide, then we move on to the next. Okay, how can we define a trademark? The more you delay, the rate will live. Yes. If you can speak up. Great. He has just given examples. Logo, whatever, which identify a certain company, and you can register it. Okay? Let's take that as the definition. What purpose do trademarks serve? Yes. Mm-hmm. Beautiful. Thank you very much. Thank you. So trademarks help us to distinguish the goods or services of one enterprise from those of another. Like, for example, if you want to go and buy toothpaste, some of you have your own preferred brands. Okay? You have a shelf with different types of toothpaste. But you go for the brand that you identify. This one is for such a company. Me, I go for this one. So trademarks actually help us to distinguish the goods of one company from those of another company. That's what it means. Any examples of trademarks we know? Come again? Coca-Cola, Speak up. Stock margarine. Okay, stock margarine. That one, we pause it for now. Unilever. Unilever. Yes. Okay. Potras. Potras, okay. Is that a logo? That's a logo, isn't it? Yes, okay. Is it what? Is it core? Yeah. I can understand why. Thank you very much. Okay. Let me quickly give you those examples. I just try to put the examples that you know. If you go to the computer world, you want to buy a computer, you see this, you see this, then you make a choice. Okay? Even when you just see this, you know that it is okay. Good. When you see this, this, okay. If you see a car having this Mercedes-Benz, this Toyota, okay. This one is obvious. Okay. Then there is in the telecommunication world, and there is also Tele1, Net1. Yes, Net1 is there. So these are just examples of trademarks. Trademarks are registered for a period of 10 years, but you can continue renewing that after every 10 years. So in principle, if you continue renewing, the trademark may not expire. Okay? So they are protected for every 10 years. After 10 years, you may renew, another for another 10 years, another 10 years, another 10 years, until Jesus comes. Okay, functions of a trademark. It shows the origin or source of a commodity or service. Okay, trademarks also help us to make a choice, because we have certain brands which are our preferences. As a consumer, we choose using a trademark. Okay, quality. Sometimes there are certain trademarks which you think, this is a better brand, they produce quality products, and you go for that. When marketing, also you use trademarks, and then for economic benefits, you use a trademark. It's a business asset. You can license others to use your trademark. Okay. Types of trademarks. There are service marks, which enable consumers to distinguish different services, such as, for example, airlines, insurance companies, car rentals, and so on. And there are collective marks. A collective mark is owned by an association or a group of companies whose members use the collective mark. Okay. Do we have any examples of collective marks in Zimbabwe? Yes. Rainbow Towers Group. Okay. Rainbow Towers Group. Any other? Yes. Come again. Tumamba. Go. Bupta Transit. Anyway. Is it Zimbabwean? Oh. Sorry, I'm Malawian, so some of these things I am hearing for the first time. Thank you very much. Thank you very much. Okay. And then you have certification marks. Any company can apply for a certification mark as long as it complies with a defined set of standards. Okay. Do you have any company in Zimbabwe or body that certifies products? Is this bottle water certified? Is it there? Are you sure? Are we safe? I don't think they can do it without. It's not there. Oh, okay. Anyway, I just took one bottle only, so. Okay, so that's an example. You say it's Standards Association of Zimbabwe, isn't it? Yes, that's it. Okay. Good. Why is it important to protect a trademark? A trademark is protected or secured by registration. So if you want to register your trademark, you can go to the National IP Office or a regional office. What happens is this. If you are applying for either a trademark or a patent, let's say a patent, for example, you don't want to go to ZIPO, Zimbabwe Intellectual Property Office. You want instead to go to apply through ARIPO. What it means is that because we have 19 member states, you can choose which countries you want your invention or trademark to be protected. Okay? For the patents, we have 18 member states which 18 member states which the Harare Protocol. So you can choose any of the 18 member states. For trademark, we have a protocol. It's not the Harare Protocol. We have what we call Banjul Protocol on marks. Banjul is in Malawi, isn't it? Huh? Banjul, where is it? You don't do geography. Oh. Banjul is in the Gambia, West Africa. So That's where the Banjul was adopted anyway. So the Banjul Protocol was adopted. So with the trademark, we have 10 member states, and therefore 10 member states which are party to the Banjul Protocol. If you want to apply for registration through a repo, you can choose any of the 10 member states. So in your application, you indicate which countries you want your trademark to be protected. Okay? It's very easy and cheaper, because without the regional system of protection, it would mean if you want to protect in 10 countries, you go to this country, you go to this country. The applications will be in different languages depending on the national laws. You pay fees in different currencies and so on. But you just come to, you apply through a repo. It's just one shop where you find everything. You are home and dry. Okay, so that's how protection is done. And protection, important, it ensures that the owners of the marks have the exclusive right to use their trademarks to identify their goods or services. In other words, once you are protected, if you register a trademark, it is a proof of ownership. You can affix those trademarks on some of your products. You can also authorize others to. I picked